Welcome to The Explainer. Today, we're diving into a massive legal tug-of-war in India, where the very survival of companies is on the line. It's a fascinating story about two really powerful laws, built for totally different reasons, that are now clashing over the same corporate assets.
So let's get right to the heart of it with this question. What happens when the law designed to rescue a company, to save it from going under, smashes right into the law designed to seize its assets because they might be linked to a crime? You've got corporate rescue on one side, criminal justice on the other. Who comes out on top?
All right, to really understand this clash, you first got to meet the two main players in the ring. In one corner, we have the Insolvency and Bankruptcy Code, you'll hear it called the IBC, and in the other corner, we have the Prevention of Money Laundering Act, or the PMLA.
Now, what's really interesting is that these two laws basically live in different universes. The IBC, which came about in 2016, is a civil law. Its whole purpose is to be a rescuer, to salvage a struggling company, get it back on its feet, and make sure its assets are worth as much as possible for everyone involved. But the PMLA from 2002, that's a penal or criminal law. Its goal is completely different. It's the enforcer, designed to fight crime and grab any assets that are considered proceeds of that crime. So one's here to rebuild, the other's here to punish.
So you can probably see where this is going. How does this turn into a full-blown conflict? Well, it happens when both of these laws stake a claim on the exact same company assets, and that's when you get a legal head-on collision.
The real root of the problem comes down to a clash of what lawyers call supremacy clauses. See, Section 238 of the IBC pretty much says, hey, if any other law disagrees with me, I win. But here's the kicker. Section 71 of the PMLA says the exact same thing about itself. It's like both laws are standing on a table shouting, I'm the boss.
And here's where you can really see the paradox. Under the IBC, as soon as a company gets into insolvency, this thing called a moratorium kicks in. It's like a big pause button that freezes everything to protect the company's assets so a rescue can happen. It even offers a clean slate from past offenses for the new owners. But the PMLA lets the Enforcement Directorate do the complete opposite. It can swoop in, attach, and confiscate those very same assets if they're even suspected of being tied to crime. So you've got one law trying to build a protective shield around the assets, and the other trying to break right through it.
So, with the laws stuck in this deadlock, everybody naturally turned to the courts, hoping they could untangle this mess. The idea was that judges would give a clear answer. But, as you're about to see, that just made things even more complicated.
Honestly, the courts have been all over the map on this. You had cases like Donner Foods and Varsana Ispat, where the tribunal basically said, look, PMLA is a criminal matter and the IBC's civil pause button doesn't apply to it. But then, you have the Shiv Charan case where the Bombay High Court said the exact opposite, that the IBC's clean slate promise means those attached properties have to be released. And just to make it more confusing, the Supreme Court in the Bhushan Power case seemed to say, hey, the PMLA guys are in charge of their own turf. It's created this huge cloud of uncertainty.
Okay, so in the middle of all this chaos, a new circular comes out from the Insolvency and Bankruptcy Board of India, the IBBI, and it offers a glimmer of hope. It doesn't try to rewrite the laws, but instead it points to this really clever little mechanism that's already sitting inside the PMLA itself.
And this new idea all hinges on one specific part of the PMLA, Section 8, Subsection 8. You can think of it like a safety valve. What it does is give the special court that's handling the money laundering case the power to actually give back a confiscated property, but only if it goes to a legitimate claimant who had nothing to do with the crime.
So here's the new game plan. This IBBI Circular basically creates a formal process. The insolvency professional, or IP, can now go straight to the PMLA court and make their case. They have to prove, hey, we have a legitimate claim to this property, and, more importantly, the company we're trying to save wasn't involved in the crime. If they can do that, the court might just agree to restore the property. It's a way to open a conversation between these two worlds.
Okay, so why does all this legal back and forth really matter to you? Well, if you're an investor looking at buying a distressed company or you're an IP trying to manage one, this fight has huge real-world consequences. So let's break down what this actually means for you on the ground.
These steps are pretty much non-negotiable now. First, you have to do incredibly deep due diligence to find out if there are any PMLA skeletons in the closet. You've got to try and separate the so-called tainted assets from the clean ones. Be totally transparent with everyone. And your rescue plans, they now absolutely need specific clauses that address what happens with these PMLA-attached assets. And don't forget, this isn't just an India problem. You need to check if assets overseas could be at risk, and keep an eye out for other agencies that might be watching too.
So, this new IBBI circular gives us a playbook, a path forward. But that fundamental tension between a law that wants to rescue and a law that wants to punish, it's still there. Which leaves us with a big final question. Is this a real permanent peace treaty that finally brings these two powerful laws together? Or is it just a temporary truce in a corporate tug of war that's far from over? I guess only time will tell.